You can challenge the 6-month administrative suspension of your privilege to drive in New Hampshire through a hearing process at the New Hampshire DMV. In order to obtain a hearing at the New Hampshire DMV, you must send in a written request, which your lawyer will do for the hearing within that 30-day window after the arrest. The scope of that hearing is different than a DUI trial or in a courtroom. The scope of the hearing is set forth on the back of the administrative license suspension form. The issues there are whether the officer had reasonable grounds to believe that you were driving a vehicle on a way under the influence of drugs or alcohol. He has to explain the facts upon which those grounds to arrest are based. He has to prove that he made an arrest or informed you that you were charged with DUI. Further, that he informed you of the implied consent rights, paragraphs 1 through 6 on the front of the form. And lastly, either you refused a test, he has to prove the refusal, or he has to prove that you consented to a test that resulted in a valid sequence 0.08 or higher on a breath test. If your blood was drawn and there was not a breath test, that takes several weeks for the state lab to report back to the police department your blood results. So that 30-day window where your privilege will be suspended doesn't go into effect until 30 days after the blood is reported back to the police and they notify you. Same with the hearing. Your window to request a hearing starts 30 days after the blood results have been submitted to the police department and you were notified of those results. This administrative hearing process at the New Hampshire DMV is critically important to the preparation of any DUI defense. A qualified New Hampshire DUI defense lawyer is always going to request that hearing and will never pass on the opportunity to conduct that hearing. Most importantly, because number one, the officer has to show up in order for the suspension to be affirmed, but the officer also has to answer questions about the reason, facts, grounds for the arrest. That officer is under oath. It is an opportunity to ask questions of the officer, obtain a transcript, and that sworn testimony and that transcript can be used later in a courtroom defending the DUI charge.